Okay. All right, let's bring up Mr. Wells first.
That's up third, Sister Deputy Officer. Go ahead, sir.
Mr. Wells, good morning, sir. My name is Brad Gardner. I'm a judge in Magistrate Court of Clayton County. Your lawyer is here on the call. I caution everyone that you have taken advantage of the opportunity to hire a lawyer. Please let your lawyer speak on your behalf. Anything that you may say during this proceeding is not privileged or private. And this is being broadcast on YouTube. So don't say anything you wouldn't want the whole world to know, okay?
Yes, sir.
So, Mr. Githaya, Mr. Wells is charged with 3 misdemeanors and 1 felony. The first misdemeanor is carrying a weapon or a long gun at the airport. Bond's going to be set at $3,000 for that offense. The second misdemeanor charge is reckless conduct. Bond is also going to be set at $3,000. There is going to be a $5,000 bond set on the discharge of a firearm on the property of another. And I have actually, bond is going to be denied on the possession of a firearm by a convicted felon. It appears that there is a probation warrant for your client's arrest out of Covington, Georgia. So it's being denied just outright, but being denied also pursuant to 1710-1 of OCGA, of the Official Code of Georgia. Always let lawyers speak on behalf of their client and tell me anything that you want me to know about your client or the case, but it's like I can't set a bond no matter what you tell me here today.
That was my question, Judge. Is it the court's interpretation that because he has an open probation case, that charge in and of itself is not bondable by the magistrate court?
Yes, I'm actually, the statute is OCGA 1710-3B. And it says a parolee or probationer charged with a misdemeanor involving physical injury or an attempt to commit physical injury or terrorist threats or with a new felony shall not be entitled to bond pending a hearing on the revocation of his or her parole or probation, except by order of a judge of the Superior Court, state court, or magistrate court. And so basically, how that has always been interpreted by me is that theoretically you can speak to the prosecutor this afternoon and they consent to a bond and he can get a bond, but it has to be something where the other side is participating, and they may say, no, we're not going to do it, or they may say, let's put it down for a hearing. I don't know what they will say, but I cannot set bond without there being a hearing.
I understand, Your Honor. And based on that, I won't be making any argument this morning.
Okay, there's gonna be a stay away provision to stay away from 7060 Spine Road, Atlanta, Georgia, and that's basically where the airport is located. That, of course, is a public place and the condition can change as it relates to that. He's going to have a preliminary hearing date set for January 10th at 8:30 in the morning, courtroom 201. And he's going to also have a bond hearing set for January 14th at 8:30 in the morning, courtroom 201. Is there anything else on behalf of your client?
No, Your Honor. I appreciate those dates, and I appreciate the court. Nothing further from the defense. I would, if you would allow me just to address Mr. Wells. Mr. Wells, I'll be in contact with you. Please don't communicate with anyone unless it's me, okay? Your jail calls are being recorded, word for word. Thank you, Your Honor.
You're welcome. You're free to go, and Mr. Wells is free to go back.
Thank you, Your Honor.
You're welcome. Okay, let's bring up Mr. It was Michelin. Was that Michelin?
Michelin, Judge.
Matillion. I'm sorry for butchering your client's name.
And Judge, you could bring his sister in, please. Oh, you said she was going to be able to watch on YouTube. That's right.
Yes.
Okay.
Yes, because as you saw with my having to remove the media people, I have more control over lawyers than I do over other people. So, Mr. Mitchell, and you're in the same position as Mr. Wells to the extent that you've taken advantage of the opportunity to hire a lawyer. So I'm going to speak to your lawyer here today. Please don't say anything about your case or anything you wouldn't want the whole world to know, because this is going to be on YouTube. Okay, sir?
All right.
Okay. Mr. Bernstein, your client is charged with one count of criminal damage to property in the second degree. That's a felony offense. I placed a $5,000 bond on this offense, and I placed a stay away provision to stay away from 5174 Riverdale Road, which is, it appears to be some sort of restaurant establishment.
Yeah.
He's going to have a preliminary hearing date set for January 10th at 8:30 in the morning, courtroom 201. But as I do always, I'll give you the opportunity to tell me anything you want to tell me about your client or this case.
Well, Your Honor, James, I've been speaking with his sister all morning, and from what I've gathered, so the incident location is where James, it's a restaurant where he's employed. James is taking on a full slate of classes at Omni Tech College, and he was also working full time. And I believe just sort of some existential issues kind of got the best of him and might have bitten off more than he can chew. He has been living with his sister and will continue living with his sister, who has essentially raised him since he was young, I think about 5 years old. I'm not sure if pretrial vetted him, but I would ask that if not, that he be vetted for pretrial to see if he can be released on pretrial without having to post a bond, given that is a student and he is, or at least maybe was, working full time.
Well, there's sort of a process that goes in place with that, and that is normally a decision that's made by the chief judge. I'm trying to pull up his criminal history.
And that, of course, is something I can't speak to, as I haven't been provided a GCIC or NCIC
Right.
thing.
I'm sorry, there's literally about 500 pages of stuff that I have to go through, and sometimes it's not in the right order. Okay, let's see. I'm getting close.
Understood.
Okay. Sometimes it gets out of alphabetical order. Okay, it looks like your client does not have a criminal history. What I'm going to do is reduce the bond to $2,500.
Okay, thank you, Your Honor.
You're welcome. Is there anything else?
If I could just address James real quick. James, I'm in contact with your sister, and you'll have my contact info to call me once you get released. It does take some time for the release process to go through. So just be patient, okay?
Oh, thank you.
Okay.
Okay, Mr. Michelin is free to go back, and Mr. Bernstein, you're free to go.
Thanks, Judge.
You're welcome. Let's bring up Mr. Hernandez.
Morning, Judge.
Good morning, Ms. Bermudez. How are you?
I'm well. How are you?
I'm making it. We got a lot of stuff going on today.
Judge, for whatever reason, I do not have Mr. Hernandez.
He is on the calendar under Flores and between Hubbard.
Okay, Judge, if you don't mind giving me just his name and
Sure.
case
It's
number.
Juan Hernandez, and he has 3 warrants. The first one is 2021 WA 20292. The second one is 2021 WA 20295. And the third one is 2021 WA 20297.
Yes, sir. Thank you.
Okay. Mr. Hernandez, sir, can you hear and understand the interpreter?
Señor Hernández, ¿puede usted escuchar y entender a la intérprete?
Un poquito. Sí,
Yes.
Sir, this is your first appearance hearing before the Magistrate Court of Clayton County.
Señor, esta es su comparecencia inicial ante el Tribunal de Primera Instancia del Condado de Clayton.
ajá.
I'm not here to take a plea in your case or to have a trial in your case. I'm here to tell you you've been charged with 1 count of driving a vehicle without a valid license.
Yo no estoy acá para aceptar una declaración en su caso o para tener un juicio en su caso. Yo estoy acá para decirle que a usted se le acusa de un cargo de manejar sin licencia de conducir.
Bond's going to be set at $1,000 for that offense.
Y por ese delito su fianza va a ser de $1,000.
You also have 1 charge of driving a vehicle without insurance.
Usted también tiene un cargo de manejar un vehículo sin aseguranza.
And the bond is also going to be set at $1,000 for that offense.
Y la fianza también va a ser de $1,000 por ese delito.
And 1 count of driving a vehicle with an expired or invalid tag. Bond is going to be set at $500.
Y un cargo de manejar un vehículo con las placas vencidas o no válidas. Y su fianza va a ser por ese delito de $500.
Do you believe you can post this total bond of $2,500?
¿Cree usted que va a poder pagar su fianza un total de $2,500?
Pues solamente conectando a mi familia ya lo pueden pagar.
Repita.
Solamente hablando de mi familia les pueden pagar.
Once I call my family, they'll be able to pay it.
Okay. Sir, you're going to have a preliminary hearing date set for January 11th at 8:30 in the morning, courtroom 201.
Señor, usted va a tener su audiencia preliminar programada para el día 11 de enero a las 8:30 de la mañana en la sala 201.
That date will get waived when you bond out and you will get a new court date in the mail.
Esa fecha o esa audiencia se cancela tan pronto usted pague su fianza y salga y usted recibiría un nuevo citatorio por correo.
Would you like for me to see if you qualify for the appointment of a lawyer?
¿Le gustaría a usted que yo vea si usted califica para nombrarle un abogado?
Sí.
Yes.
I'm going to find that you qualify, sir. I'm going to appoint a lawyer to represent you. Do you have any
Yo
questions
voy a
for me?
encontrar que usted califica, señor, y le voy a nombrar un abogado para que lo represente. ¿Tiene usted alguna pregunta para mí?
No.
No.
Okay, sir, you're free to go back.
Ok, señor, puede retirarse.
Gracias.
Thank you.
Thank you for your help, Ms. Bermudez. You are free to go. Have a good day.
Yes, sir. You too. Thank you.
Okay, let me read the script now to everyone that's remaining. Good morning, everyone. This is your first appearance here before the Magistrate Court of Clayton County. My name is Brad Gardner, and I'm a judge in this court. I'm here to inform you of the charges that have been filed against you, to advise you of certain rights, to set bail on those offenses that I'm authorized to set bail, to schedule a preliminary hearing, and to determine whether you require the assistance of an attorney. You have the right to remain silent and say nothing. But should you give up this right, anything you say during this proceeding may be used against you. So please don't discuss the facts of your case. During this and all other proceedings, you have the following rights: to the presumption of innocence, to indictment by a grand jury for most felonies or by accusation for misdemeanors, to a speedy and public trial by jury, to see, hear, and question witnesses who are called to testify against you, to compel the attendance of witnesses to testify on your behalf, to testify on your own behalf or offer evidence of your own defense, and to have an attorney represent you. If you cannot afford an attorney, one can be appointed to represent you if you qualify. Some of you will be allowed to post unrestricted bonds for your release from jail. These bonds may be posted by cash, commercial, or property. Some of you will have special conditions on your bond that prohibit you from contacting certain people or going to certain places. You will also be prohibited from contacting the victim while you are in jail. If you violate the court's order, your bond will be revoked and you can remain in jail until your trial. You could also receive additional felony charges. It is important to note that if someone is listed as a victim in your case, that person will not be allowed to post your bond. Some of you are charged with offenses for which this court is not authorized by law to set bail. In this event, a bond hearing will be scheduled before a judge of the Superior Court of Clayton County, and you will be informed of that date. If you are currently on active probation, this court is not authorized to set bond at this time. Where the bond is appropriate in your case will be reconsidered after your probation officer has had an opportunity to consider this new arrest. The purpose of a preliminary hearing is to determine whether there is sufficient evidence to support the allegations against you. The standard at this stage is very low. A judge determining whether a charge goes forward at this stage only has to determine that it is possible that the crime occurred. Everyone has the ability to waive their right to a preliminary hearing. However, you should speak to a lawyer first if you are unsure about whether it is appropriate to waive your preliminary hearing. If you post bond, your preliminary hearing is automatically waived. You will receive notice at the address you give of your next court date. Lastly, could I have everyone raise your right hand, please? Do you swear or affirm any statements you make during this proceeding will be the truth, the whole truth, so help you God? Okay, let's switch over to the ladies' side, and we can start with Miss Bell.
Bell, yes, ma'am.
Ms. Bell, ma'am, you're charged with one count of criminal damage to property in the second degree. That's a felony offense. I've set a bond at $5,000 for that. You're also charged with one count of simple battery. I've set a bond also at $5,000 for that. So that's a total bond of $10,000. Do you believe you can post that bond?
Yeah.
Your preliminary hearing date is going to be set for January 10th at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out, and you'll get a new court date in the mail. I'm also going to place a stay away provision on the bond to stay away from an ivory mirrors. Do you understand that?
Yes.
Would you like for me to see if you qualify for the appointment of a lawyer?
Yes.
Okay. All right. I'm going to find that you do qualify, ma'am. I'm going to appoint a lawyer to represent you. Do you have any questions of me?
If I don't have a criminal background, is that helpful today?
Okay, let me see. Okay. Well, this is your first arrest also. I am going to do what I did in the other case and reduce this to 2,500 on the criminal damage to property and $3,000 on the simple battery. The stay away provision is going to stay in place. Any other questions, ma'am?
Am I able to put anything out, like a restraining or anything out on him as well?
I have no idea, ma'am.
Okay,
Okay, it's possible, but that's why we get you a lawyer so you can talk to the lawyer about it.
okay.
Okay. Anything else, ma'am?
No, that's all.
Okay, you're free to go back. Ms. Jones. You're free to go back, Ms. Bell. Okay. Ms. Jones, ma'am, you're charged with 1 count of driving a vehicle with no insurance and 1 count of simple possession of a Schedule II narcotic. I'm set to bond at $1,000 on the driving with no insurance charge and $3,000 on the possession of a Schedule II narcotic. Now, that is a felony offense. So you're going to have a total bond set at $4,000. You're going to have a preliminary hearing date set for January 10th at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out and you'll get a new court date in the mail. You refuse to fill out your form. Are you going to hire your own lawyer?
That's my plan, because I'm not sure of the income requirements to get a public defender.
Okay, well, that's why we give you the form so you can fill it out and we can make a determination.
Okay.
But you have the right to hire your own lawyer, so that's what I'm going to put down. Okay.
Can I change that to see if I qualify?
Are you currently working, ma'am?
Yes, sir, I'm a nurse.
How much do you make per hour or per month?
I make $39 an hour.
Okay. I'm going to find that you qualify, ma'am. I'm going to appoint a lawyer to represent you. Do you have any other questions?
No, sir.
Okay, ma'am, you're free to go back. Ms. Owens? Ma'am, you're charged with 1 count of driving a vehicle on a suspended license. Bond is going to be set at $1,500. For that, you're also charged with 1 count of driving a vehicle without valid insurance. Bond is going to be set at $1,000 for that offense. And finally, 1 count of driving a vehicle on an expired or invalid tag. Bond is going to be set at $500. Do you believe you can post this bond, ma'am? It's a total bond of $3,000.
$1,000, it's a possibility.
Okay. Your preliminary hearing date is going to be set for January 11th at 8:30 in the morning, courtroom 201. The date will get waived upon your making bond and you'll get a new court date in the mail. Do you want me to see if you qualify for the appointment of a lawyer?
Yes, I'll fill out the paperwork, but it may not have gotten to you guys yet.
Well, you filled it out. I'm going to find that you qualify, ma'am. Do you have any questions of me?
I do. I know that you set the bond at 3,000, but I was asking, I'm currently in an IOP program for intense outpatient programming, mental health. And I was seeing if you do signature bonds or anything of that nature, if I can't post the 3,000 before I don't get kicked out of my program.
These bonds are set by schedule, which means they're automatically set. A group of judges have gone through and made a determination of what they believe to be appropriate bond for differing charges. So I am going to leave it the way that it is now.
Okay.
This is something that you most often are likely, because they're driving related offenses, can get resolved pretty quickly through the Solicitor General's office.
Correct.
Okay.
All right, but you said 3,000?
Yes, ma'am.
Okay, thank you.
You're welcome. You're free to go back.
All right.
Miss, is it Wapples? Waples. Ma'am, you're going to be charged with 1 count of battery. Bond is going to be set at $5,000. Do you believe you can post that bond? Did you say no?
I have to talk to my mom.
Okay. I'm gonna put a stay away provision on the bond to stay away from Jaquetta Whittle.
Yes, sir.
Your preliminary hearing date is gonna be set for January 11th at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out, and you'll get a new court date in the mail. And ma'am, you're pretty young. I don't know what has you in this situation, but life is going to be pretty hard if you believe you can just live your life in this manner. Okay.
I understand.
All right. Do you want me to see if you qualify for the appointment of a lawyer?
Yes.
I'm going to find you qualify, ma'am. I'm going to appoint a lawyer to represent you. Do you have any questions of me? Okay, ma'am, you're free to go back.
And then, Your Honor, we skipped over Miss John. I said John.
Oh, I'm sorry.
He come in.
Oh. And this is Isha John. I'm sorry. I totally had you in the wrong stack, man. You're charged with 1 count of family violence battery. Bond is going to be set at $5,000 for that offense. 1 count of simple battery. Bond is going to be set at $4,000. 1 count of criminal trespass, damage to property. Bond is going to be set at $3,000. These are all misdemeanor offenses, so your preliminary hearing date is going to be set for January 11th at 8:30 in the morning, courtroom 201. There's going to be a stay away provision on this bond to stay away from a Hetherin Greenaway and Fawn Roberts. Do you understand that? Do you believe you can post this total bond of $12,000? You would you like for me to see if you qualify for the appointment of a lawyer?
I do currently have a lawyer.
Okay. Do you have any questions of me?
Yes, sir. Being that this is my first offense, I do have a 6-month-old baby at home and a daughter at home that has no other support but me. I wanted to know if there anywhere that I could get a signature bond or something.
No, ma'am. And I'll tell you why. As an adult, you have control over what you do with your body. And the allegations here are that you were doing things you shouldn't have been doing. And so I don't believe that that's something where you can go and act out in a certain manner, then say, well, just let me out of jail. And I promise I won't do it anymore. So that request is going to be denied. Anything else, ma'am? Okay. You are free to go back.
Open the door, sir, please. That's gonna be everyone on the female side, Your Honor.
Thank you for your assistance. Have a good day.
You too.
Let's switch over to the male side. Yes, sir. You are Mr. Allen?
Yes, sir.
Sir, you're charged with 1 count of possession of marijuana less than an ounce and 1 count of use of possession of drug-related objects. Bond is going to be set at $1,500 for each offense. So that's going to be a total bond of $3,000. Do you believe you can post that bond, sir?
Yes, sir.
Your preliminary hearing date is going to be set for January 11th at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out and you'll get a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
Oh, sir.
Okay, you're gonna hire your own lawyer?
No, I'll take the lawyer you get.
Oh, okay, you do qualify, sir. I'm going to appoint a lawyer to represent you. Do you have any questions for me?
No, sir.
Okay, you're free to go back. Is Mr. Davis or Flores? No, Mr. Davis is next.
How you doing, Your Honor?
Good morning. Are you Mr. Davis?
Yes, Your Honor.
Sir, you're charged with one count of aggravated assault, one count of home invasion in the first degree, one count of cruelty to children in the third degree, which is a misdemeanor. I've set bond at $5,000 on that charge, and one count of cruelty to children in the first degree, which is a felony. I cannot set bond on the home invasion in the first degree charge at this point. So I'm denying bond on the aggravated assault by strangulation and the cruelty to children in the first degree. There's going to be a stay away provision on the bond to stay away from a Lucinda Cotum Velasquez. Do you understand that?
Yes, Your Honor.
Your preliminary hearing date is going to be set for January 10th at 8:30 in the morning, courtroom 201. That date will remain until your bond hearing. You're going to have a bond hearing set for January 14th at 8:30 in the morning, courtroom 201. Did you fill out a form for a court-appointed attorney, or you're going to hire your own lawyer? Okay. I must have misplaced your form. Are you currently working, Mr. Davis?
No, Your Honor.
Okay, I'm going to find that you qualify. I'm going to appoint a lawyer to represent you. That's going to be the Public Defender's Office here in Clayton County. Do you have any questions for me?
No, Your Honor.
Okay, sir, you're free to go back. I have a, are you Mr. Flores?
Yes, sir.
Hold on one second. Deputy, is Tremaine Davis OTB?
Your Honor, I do not, step aside, honey. I do not have him on my calendar, Judge.
Okay, he's charged with offenses that he could bond out, and I didn't get a bond order, and that normally tells me that he's bonded out.
You probably did.
So I'll check him. I'll just make a notation to check him.
Okay, Judge.
Okay, let's bring Mr. Flores back up. Mr. Flores, sir, you're charged with one count of violation of Georgia Controlled Substance Act, simple possession of methamphetamine. I'm going to set the bond at $3,000 for that offense. You're also charged with one count of possession or use of drug-related objects. I'm going to set the bond at $1,500. Do you believe you can post this bond of $4,500?
I believe so, sir.
Okay. There's going to be a preliminary hearing date set for January 10th at 8:30 in the morning, courtroom 201. But that date will get waived upon bonding out, and you'll get a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
Sir, yes, sir.
Okay, you do qualify. Sir, I'm going to appoint a lawyer to represent you. Do you have any questions of me?
Yes, sir. Being that is my first time, is there any way I could get a reduced bond?
No, I'm not. I've already, in my mind, reduced the bond as it relates to the simple possession of felony amounts of drugs. But you're going to have to do the work to not get yourself in this situation, okay?
Sir.
All right, you're free to go back. Mr. Hubbard? Sir, you're charged with possession of marijuana less than an ounce, which is a misdemeanor offense. Bond is going to be set at $1,500. You're also charged with one count of driving on a suspended license. Bond is going to be set at $1,500. That's a total bond of $3,000. Do you believe you can post that bond?
Yes, sir.
It looks like there was another charge that didn't make it to my bond order, but I dismissed that charge or denied that charge. It said improper erratic lane change. So I'm just gonna, but it looks the problems though. the warrant numbers are all messed up. I'll figure it out on the back end, but you're just going to have 2 charges. And the reason I say that, because I got to make certain that I have addressed each issue that may be pending so that you're just not stuck in jail. Your preliminary hearing date is going to be set for January 11th at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out, and you'll get a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes, sir.
You do qualify, sir. I'm going to appoint a lawyer to represent you. Do you have any questions for me, Mr. Hubbard?
No, sir.
Okay, sir, you're free to go back.
Yeah.
Is it Mr. Johnson?
Yes, sir.
Mr. Johnson, sir, you're charged with a number of driving related offenses. Bond's going to be set on each one of these. You're charged with 1 count of having an altered tag. Bond is going to be set at $500. 1 count of use or concealing the identity of a tag. Bond is going to be set at $500. 1 count of driving a vehicle without insurance. Bond is going to be set at $1,000. 1 count of driving a vehicle on an expired or invalid tag. Bond is going to be set at $500. Mr. Johnson, sir, I'll let you say whatever you want to say to me, but I got to get through this, okay?
I'm sorry. Yes, sir.
No problem. 1 count of misdemeanor possession of marijuana less than an ounce. Bond is set at $1,500. And 1 count of use or possession of drug-related objects. Bond is set at $1,500. So that's going to be a total bond of, let's see, 2, 3, looks like $3,500. Do you believe you can post that bond?
I'm not sure.
Okay. Your preliminary hearing date is going to be set for January 11th at 8:30 in the morning, courtroom 201. That date will get waived upon your ability to bond out. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes, sir.
I'm going to find that you qualify, Mr. Johnson. I'm going to appoint a lawyer to represent you. Now, I cut you off. What is it that you wanted to tell me?
But you said that I paid the ticket for my to have a driver's license to Huddle, Texas, and I called the number on the back of my license, and they made sure it was valid. I don't understand why it's not, sir.
I don't understand either, but that's why we appoint lawyers as quickly as possible. Please speak with your lawyer about this. It could be some kind of paper mishap, but I would also encourage you that because you don't want to go to jail because of some paper mix-up, if you've paid stuff like that off and it relates to a vehicle, keep it in your glove compartment.
But see, the thing, Judge, I had paid it over the internet, and I didn't never get. Only thing I got is a receipt on my email, and
that's the documentation that I'm saying keep in your possession at all times.
I have it.
Okay. Well, this could be a mix-up. I mean, and I would hate for you to have to spend time in jail because of a mix-up. But at this point, I don't have the ability to be your legal advocate.
I got you.
Okay.
Yes, sir.
Make sure you tell your lawyer everything you just told me.
I sure will.
Okay. Have a good day, sir.
Thank you. Yeah.
Mr. Kemp, sir, you're charged with 1 count of family violence battery. Bond is going to be set at $5,000. Do you believe you can post that bond?
Yes, sir.
There's going to be a stay away provision on this bond, a stay away from an Aisha Johnson. Do you understand that?
Yes, sir.
Your preliminary hearing date is set for January 11th at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out, and you'll get a new court date in the mail. Now, looks like you may make a little bit too much money to qualify for the appointment of a lawyer.
Okay.
Okay, so looks like you're gonna have to hire your own lawyer. Is there anything else, Mr. Kemp?
What else, having kids together? How would that work? How would I figure that out?
So this is the point where, you know, these are the tough questions and people ask that question every day. I don't know you. I don't know Ms. Johnson. All I know is something happened and you were brought before me. So we place bright lines on this in the beginning because we don't know if this was just a bump in the road or just another day ending in Y.
Right.
And so you can, or she can, if she's not afraid of you, contact the Solicitor General's office. Now, you can't go telling her to do this, but she can contact them and ask them to change this stay away provision to something else, and they will look into it and consider it. But they have access to speak to her directly to know exactly what she wants to do.
Okay.
As it relates to the children, do you have any kind of custody arrangements in place?
I don't.
Okay, so that's going to be tough on the short term, but hopefully this was just a bump in the road and this stuff can get worked out. All right, you're free to go back, sir. Mr. Langdon. Mr. Langdon, sir, you're charged with 1 count of criminal trespass, family violence. Bond is going to be set at $3,000, and 1 count of possession of marijuana less than an ounce. Bond is going to be set at $1,500. Do you believe you can pay this total bond of $4,500?
I don't really know yet.
Okay. Your preliminary hearing date is going to be set for January 11th at 8:30 in the morning. Courtroom 201. That date will get waived upon your bonding out, and you will get a new court date in the mail. Now, I have placed a stay away provision on this bond to stay away from a Latressa Thomas. Do you understand that?
So I gotta stay with my mom. All right. So
She's the alleged victim in this case, yes.
Not that.
all right.
Would you
Hey,
like to?
I got a question.
Yes, give me 1 second. Would you like for me to see if you qualify for the appointment of lawyer?
Sure.
Okay, you do qualify. I'm going to appoint a lawyer to represent you. Now, what was your question, sir?
Ain't no way I can like get no sentence.
No. No.
All right.
Okay. All right, so you're free to go back.
You said my court date is January 10th?
January 11th, but that date will get waived upon your bonding out and you'll get a new court date in the mail.
All right.
Okay, free to go back. Mr. Lott. Are you Mr. Lott?
Yes, sir.
Sir, you're charged with 1 count of knowingly driving a vehicle with a suspended or canceled registration. Bond is going to be set at $500 for that offense. 1 count of possession of marijuana less than an ounce. Bond is going to be set at $1,500. And 1 count of open container violation. Bond is going to be set at $500. So you're going to have a total bond set at $2,500. Do you believe you can post that bond?
Yes, sir.
Your preliminary hearing date is going to be set for January 11th at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out and you'll get a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes, sir.
You do qualify, sir. I'm going to appoint a lawyer to represent you. Do you have any questions of me?
No, Your Honor.
Okay, you're free to go back, Mr. Lott. Mr. McCants. Mr. McCants, sir, you're charged with 2 counts of criminal damage to property in the 2nd degree. These are 2 felony offenses. Bond is going to be set at $5,000 for each offense. And you're charged with 1 count of criminal trespass. Bond is going to be set at $3,000. So you're going to have a total bond set at $13,000. Do you believe you can post that bond?
Yes, sir.
There's going to be a stay away provision on the bond to stay away from a McGill Harris Jr. Do you understand that?
Yes, sir.
Your preliminary hearing date is going to be set for January 10th at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out and you'll get a new court date in the mail. Do you want me to see if you qualify for the appointment of a lawyer?
Yes, sir.
About how much do you make per hour?
15.
Okay, you do qualify, sir. I'm going to appoint a lawyer to represent you. Do you have any questions of me?
Yes, sir. Can
What's your-
can you lower my bond?
Let me see. No. No. So this falls into the category of you have the ability to control what you do with your hands, and people want to keep their stuff too. That's the way you want to keep your stuff. So if this is the thing that's gonna help you not, help you not be in that position again, then I'm gonna leave it there. So what else did you want to tell me? Okay, you're free to go back.
Tomorrow. Water.
1300 gang.
Mr. Morris, sir, you're charged with one count of violation of Georgia Controlled Substance Act. I set bond at $5,000. One count of possession with intent to distribute marijuana. I set the bond at $10,000. One count of possession of a weapon during the commission of a crime. Set the bond at $5,000. One count of having a firearm with an altered serial number. I set the bond at $5,000. And one count of use or possession of drug-related objects. Bond is going to be set at $1,500. So that's going to be a total bond of $26,500. Do you believe you can post that bond?
I hope so.
Your preliminary hearing date is going to be set for January 10th at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out, and you'll get a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes.
You do qualify, sir. I'm going to appoint a lawyer to represent you. Do you have any questions of me?
I mean, not really, but I was in I was going to pick baby mama club, and like the stuff that they found in the car is not even my car. I didn't even know it was in there.
So again, Mr. Morris, that's why we try to get you lawyers as quickly as possible so that you can begin putting your defense together. These are the allegations that have been levied against you, and it's my duty to either set bond or not set bond, and to appoint lawyers so that you can begin the process of moving this thing down the road, okay? All right, well, you're free to go back.
Water.
All right. Excuse me, sir.
Yes.
How much you set a bond for?
Oh, $26,500. Mr. Murray.
Yes, sir.
Sir, you're charged with one count of improper lane change. Bond is going to be set at $500. I'm sorry. And one count of driving the vehicle on a suspended license. Bond is going to be set at $1,500. That's a total bond of $2,000. Do you believe you can post that bond?
Yes, sir.
Your preliminary hearing date is going to be set for January 11th at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out, and you'll get a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes, sir.
Okay. I'm going to find that you do qualify, sir. I'm going to appoint a lawyer to represent you. Do you have any questions of me?
No, sir.
Okay, you're free to go back.
No.
Okay, Mr. Noble, is he there?
Yes, Your Honor, he's right there.
Okay. There's something strange going on, Mr. Noble. We're actually trying to figure this out. It looks like you appeared for first appearance on November 25th. Is that correct?
Yesterday.
About that time?
I came in yesterday.
Well, we were looking for those warrants because we have warrants that are from November 25th. And on the warrants that I have, the officer said he took you into custody on November 24th. Jonesboro PD. Does that sound familiar?
Yes, sir.
And then we have a record that you appeared before magistrate court on November 25th on those warrants. And were you given a bond or did you post a bond?
No, sir. When I came in, they told me they had like 48 hours. Somebody didn't sign something. They had 48 hours, and the judge sent me back the date. So I guess I don't know what to do, but they said they had 48 hours to do something. And that was yesterday.
Well, that's normally what happens is a person arrested on what we call a WAA goes before a judge within 48 hours. So the 25th was Thanksgiving. Can't read. All right. So it looks like you now have charges that are false imprisonment, 3 counts, cruelty to children in the 3rd degree, 2 counts. But as it relates to the other offenses, they are aggravated assault, 5 counts of false imprisonment, 3 counts of cruelty to children, 1 count of possession of firearm by a convicted felon, 1 count of obstruction, and 1 count of simple assault. And this is all that was, it looks like the officer said that they arrested you on the 24th. So I am going to, I'm going to deny bond at this time on these new charges and figure out what happened with these warrants. There's going to be a stay away provision, stay away from Natalie Buchanan. Do you understand that?
Yes, sir. Question.
Yes, sir.
When I went to the second day I was here, they the judge had threw out child the 3rd degree. She threw that out, gave me a bond for some other charge. And like I said yesterday, they had told me they had 48 hours, and if I came back here yesterday and somebody didn't sign anything, they were just gonna take it to, I guess, to another level or something. Like they were gonna dismiss some cases or something like that. They told me somebody didn't sign the warrant.
Well, that's what I plan on doing. Of signing the warrants. I just don't have them before me.
Okay, so what you saying now?
Okay, so this is your first appearance on these warrants, and I'll read the warrant numbers out to you if you want me to. There's 2021 WA 20198 through 2021 WA 20203. Okay, those are the ones that are attached to the November 29th arrest. Those are the warrants that I don't have. There are warrants that start at 2021 WA 19988 that goes through 2021 WA 1993. And it appears that you came before first appearance on Thanksgiving Day. And those are the warrants that I have now. So all I'm trying to do is figure out what happened so that you're just not floating around. Okay. So that's why I'm trying to have this conversation with you And I understand that you want these charges to be dismissed. I understand that. I get that. But I got to figure out what happened. And if you can't give me information, that's fine. I'm just going to have to figure it out.
I can give you information. What information do you need, sir?
These new warrant numbers for 4 counts of false imprisonment, 2 counts of cruelty to children in the 3rd degree. You said that you were brought in on the 29th.
No, I wasn't brought in on the 29th. I was brought in on
The 24th?
the 24th, sir.
Okay. So I don't know where these new warrants are coming from because I don't see anything. And we have been looking and we're going to continue to look. But right now I'm denying bond on these 4 false imprisonment and 2 cruelty to children in the 3rd degree.
Okay, what about the other 2 charges?
You're talking about the aggravated assault and the obstruction? That's where I'm going to have to go back and see what happened on Thanksgiving Day because I wasn't here.
Oh, no, they dismissed the child cruelty. I guess that's what it was. They dismissed that and they gave me a bond for some other charge.
Okay, I just received word that the new warrants have the same offense date as the old warrants. So it looks like what may have happened is the officer came and got or amended the warrants, came and got new warrants. I don't know. We'll have to figure out why the officer came back and got more warrants for the same offense date.
Right.
Okay.
Right. So I don't have a bond for no charges?
Not set by me. Do you have a lawyer?
No, I was just trying to, me and my mother and my wife were trying to figure out, like after today when I came back to call them, we were just trying to figure out what happened after today. When I came in yesterday, I just told them don't try to do anything until I figure out what the judge trying to do.
Yeah, these are some pretty serious charges.
I keep on getting the runaround.
So have I explained things sufficient to you today? And if not, ask a question.
Oh, sir, I mean, I just don't understand. Every time I come to it, it's just like a runaround. They're saying some of my charges, like I never came up before the judge and the judge said I had all them charges, first of all. Every time I came back.
I just got word that on the other offenses, you have, the only thing you have bond on is obstruction and simple assault.
Okay, and the child cruise, whatever, child endangerment.
Okay, sir. I'm gonna tell you this one more time. I have to figure it out. Okay.
Yes, sir.
Something happened. It looks like the officer got charges, then came back and amended the charges. I don't know why, but that's why I gotta ask those questions. So we can sit here for 3 hours having the same conversation about not knowing what happened, but we're narrowing it down to you have bond on 2 charges, no bond on the other charges. And I think you probably knew that, correct?
Yes, sir.
All right. So that's what I'm saying about trying to figure it out. But the one thing that's not going to happen is I'm not going to just, oh, I don't know what happened. I'm going to figure it out. Okay.
Yes, sir.
Then if you want, I'll have them bring you back tomorrow. But I'm not gonna let you languish, but I'm also gonna do my job.
Yes, sir.
Okay.
Yes, sir.
All right. Now, do you want me to appoint a lawyer to you, or do you want to hire your own lawyer?
Lawyer, sir.
Okay. I'm going to do that. So, because what I can do, which I don't have the ability to do in the morning, because I'm literally going through 500 pages of GCICs, and this morning it was 110 pages. I noticed that there was a problem. I sent out an email, and people have been working to narrow the problem down. Okay.
Yes, sir.
So when this is over and I'm not on camera anymore, I have time to just sit here and figure out what happened and what went wrong. Okay.
Sir.
All right. Anything else, sir?
No, sir. What about tomorrow? You say you're gonna bring me back tomorrow? See things out.
Do you want me to bring you back tomorrow? If so, I will.
Yes, I'm trying to figure out what's going on.
Okay. You've been arrested and charged with aggravated assault. You want me to read the warrants to you?
I know my charges, sir.
Okay. So bond is being denied on everything except for the obstruction or simple assault. I've appointed a lawyer to represent you, which is the best way to figure everything out. Okay?
Yes, sir.
Because for some reason, these charges have been, you've been charged twice with what it may be the same offense. Okay? So if that's the case, bond is going to go away on one set of offenses, or those warrants are going to go away on one set of offenses, and the warrants are going to stay the same on the other ones. I'm not going to have you charged twice with two separate tracks going on when that just makes no sense.
Yes, sir.
Okay.
Sir.
So do you want me to try to bring you back tomorrow?
Yes, sir.
Okay, then I'll do that.
Thank you, sir.
You're welcome. You're free to go back. Mr. Nyland.
How you doing, John?
I'm doing well, sir. You're charged with two driving related offenses. One is driving on a suspended license. Bond's going to be set at $1,500. And the other charge is driving on a expired or invalid tag. Bond is going to be set at $500. So that's a total bond of $2,000. Do you believe you can post that bond?
Yes, sir. I think it should already be posted.
Okay. And it looks like you're going to hire your own lawyer.
I wasn't gonna do a lawyer, actually. I'm just gonna pay.
Okay.
I want to ask you a quick question, honestly. So I got this situation, this lawyer suspended my license and he won't give me the release letter for it back, because he's saying I owe $50,000 or something that happened like 2011. They just suspended it last year, and I don't have no way, no transportation around, it's just me. So I was trying to see, is there any kind of like special term? I'm working with a lawyer right now to go through this kind of bankruptcy thing. I just wanted to see if there's any kind of work permit or anything that you provide me with so I can't keep coming to you.
Well, Mr. Nyland, how about you allow me to appoint a lawyer to represent you on this charge so the lawyer can do what lawyers do?
Okay, I didn't know that was who I was supposed to really talk to, and I don't lost on that part. That's why I asked. So do I gotta pay for it?
No, I'm gonna, are you currently working?
Yes, sir.
About how much do you make per hour?
I work on commission. I do body work and paint, so.
Give me a rough estimate of what you think you earn in a month.
Like 45.
Okay, I'm gonna find that you qualify. I'm going to appoint a lawyer to represent you. The lawyer can advise you about getting a learner's permit, or get a temporary permit, or all of that kind of stuff. That's why lawyers are there. Okay.
I didn't know that. I appreciate you.
No problem. You're free to go back.
Do you know if my bond is posted or not?
I do not. It probably has been posted because it's set by schedule, but because we move so many people around, you may have fallen into that gray area where the bond was set, I mean, was made, but it was made too late for you to just go straight to bonding. So they brought you to court.
Understood. That'll
So
work.
you'll be able to use the phone when you leave this proceeding at some point, and you'll be able to figure that out.
All right, thank you, Judge.
You're welcome. I have a, tell me your name, sir.
Carlson Russell.
Okay. Mr. Russell, sir, you're charged with 1 count of aggravated stalking. This is one of those offenses where I cannot set bond at this stage. So bond is going to be denied. There's going to be a stay away provision on the bond to stay away from a John Burnett. Do you understand that?
Yes.
Your preliminary hearing date is going to be set for January 10th at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out, and you'll get a, well,
Is there any way?
hold on. So the way that aggravated stalking works is that I cannot set bond at this stage. Aggravated stalking is violation of a TPO or an order to stay away from a certain person or have no contact or someone of that sort. Depending on what took place and the underlying allegations, the district attorney's office may decide, oh, you know what? We'll consent to a bond in this case. Or they may say, oh man, we're glad you got that guy because we've been worried about him. I don't know anything about that. I don't have access to that information. So what I can do is I can appoint a lawyer to represent you if you want me to.
Yes.
Okay, I'm going to find that you qualify. I'm going to appoint a lawyer to represent you. You're going to have a preliminary hearing date set for January 10th at 8:30 in the morning, courtroom 201. You're going to also have a bond hearing date set for January 14th at 8:30 in the morning, courtroom 201. Now, speak to the lawyer about the facts of your case so that the lawyer can help you, okay?
Okay.
All right, any other questions?
Is there a way I can talk to a lawyer to possibly get a bond before then?
It's possible, but that's where you have to communicate with your lawyer about what actually is going on with your case. But that decision is going to be made by the district attorney. Okay. Anything else?
No, that'd be it.
Okay, so you're free to go back. Okay, I think I'm getting out of order. Who do you have next? Okay. Sir, you've been charged with 1 count of driving a vehicle on expired or invalid tag. Bond is going to be set at $500. 1 count of driving a vehicle without insurance. Bond is going to be set at $1,000 for that offense. And 1 count of driving a license, driving a vehicle with the suspended or canceled license. Bond is going to be set at $1,500. So do you believe you can post this total bond of $3,000?
3?
Yes, sir.
I got a question, sir. Supposedly the truck got insurance. And supposedly that's what my mother told me when I called her. And I believe she got proof of that.
Okay. Do you want me to appoint a lawyer to represent you?
No.
Are you going to hire your own lawyer?
No, sir. Oh, well, no, well, yeah, you give me one.
Okay. I'm going to find that you qualify, Mr. Reyes. And the question that you're asking is a question that why you need a lawyer?
No.
I'm a judge. Hold on. I'm a judge. I've been practicing law for 21 years now. If I get in trouble, I'm hiring a lawyer. Okay. That's just how this stuff happens. because you're asking me questions about stuff that I have no idea about. But you sit down with your lawyer and say, hey, my mother said this is paid for. The lawyer say, well, where's the receipt? Where's the information? You give it to the lawyer go to the solicitor and say, this was paid. He never should have gotten arrested. And then say, you know what, you're right. Let's make a copy of that and let's dismiss these charges. But picking up the phone and calling people and saying it's supposed to be taken care of, and nobody knows what you're talking about.
Yes,
Okay.
sir. You're right.
All right. So your preliminary hearing date is set for January 11th at 8:30 in the morning, but that date will get waived upon your bonding out and you'll get a new court date in the mail. So mistakes happen all the time. That's why we don't sit here and make a value judgment as to whether you need a lawyer or not. If you want a lawyer and you don't make too much money to put you out of that category, I'm going to appoint a lawyer to represent you, because that's the only way that this stuff gets worked out. Okay, so good luck to you, sir.
So you said how much was it? 3,000?
Yes, sir.
Right?
Yes, sir.
Thank
Okay,
you.
you're welcome. Who do we have next? Mr. Mr. Ross, sir, you're charged with one count of driving on the wrong side of the road. Bond's going to be set at $500 for that. One count of driving a vehicle on a suspended license. Bond is set at $1,500. And a window tint violation. Bond's going to be set at $500. So that's going to be a total bond of $2,500. Do you believe you can post that bond?
Yes, sir. I just at first they told me my bond was like 3,100. I just want to know what's the difference.
Okay. So all of your bonds have been set by schedule, which means they're automatically set. The sheriff's department is required by law to add fines or fees, not fines, fees to the bond. They have the fee schedule and I don't. So when bonds are automatically set, they know exactly to the penny what you're going to have to pay. When I have to set bonds, they don't know what the bond has been set at yet, so they can't tell you the total amount.
So what you just told me is the actual number.
No.
What they told you.
Yes, because they're telling you the bond plus the fees. Okay.
Okay.
All right. Your preliminary hearing date is set for January 11th at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out and you'll get a new court date in the mail. Do you want me to see if you qualify for the appointment of a lawyer, Mr. Ross?
Yes, sir.
I'm going to find that you qualify. I'm going to appoint a lawyer to represent you. Do you have any questions of me?
Does it show anything about my bond status?
I'm sorry?
Do you see anything about my bond status thus far?
I don't have access to that. If this is the thing, if someone has been trying to post your bond, it's probably already been posted. You may be in the same position as the other person. Or as soon as you get back to your housing unit, they're going to knock on the door and tell you to pack your stuff and go.
I got you.
Okay, you're free to go back. Okay, Mr. Chip, sir, you're charged with, I'm sorry, who was that?
It's Mr. Shield, sir.
Okay. Mr. Ship, you're charged with 2 counts of battery and 3 counts of aggravated assault. I'm going to set bond at $5,000 on the battery charges, but bond is going to be denied at this point on the 3 aggravated assault counts. There's going to be a stay away provision on the bond, a stay away from a treasure broom. Do you understand that? Your preliminary hearing date is going to be set for January 10th at 8:30 in the morning, courtroom 201. You're going to have a bond hearing date set for January 14th at 8:30 in the morning, courtroom 201. Do you want me to see if you qualify for the appointment of a lawyer?
Yes, sir.
I'm going to find that you qualify, Mr. Shipp. I'm going to appoint a lawyer to represent you. Do you have any questions of me?
I just got about a couple questions. I want to know, how do I have 3 aggravated assaults if it's only supposed to be concerning 2 people? I want to know the extra assault comes from.
Okay. All right. Let's see if we can figure this out.
Because if it was 3, I should have 3 batteries as well.
Well, don't get yourself adding charges.
I ain't gonna lie, Judge. I'm free case. I'll be out. I'm free case, baby.
Okay.
This a heartbreak case right here.
All right. So 1 aggravated assault involves the allegation of strangulation, and then 2 involve the allegation of pointing a weapon. So that's the 3.
Okay.
All right.
Yes, sir.
Anything else?
No, I ain't got no more questions.
Okay. All right, sir. You're free to go back.
Thank you.
You're welcome.
It's Mr. Smith, Your Honor.
Okay. You are Christopher Smith.
Yes, sir.
Sir, you're charged with 1 count of possession of firearm by a convicted felon. This is one of those offenses where I can't set bond because it appears that you're on probation. I'm going to set a preliminary hearing date for January 10th at 8:30 in the morning, courtroom 201. I'm going to set a bond hearing date for January 14th at 8:30 in the morning. I see you didn't fill out the form. Are you planning on hiring your own lawyer?
I actually already have a lawyer. I talked to him yesterday about some other stuff that I got going on, and then after that, later on at night, they brought me back to intake to add that charge on. So, well, I'll wait later to ask you a question.
Well, I'm done talking now. Don't talk about the facts of your case.
Oh no, I'm not.
Okay, so what's your other question?
I was gonna ask, I got a lawyer already. He's already on it already. So I was gonna ask, can I come back tomorrow and he can be here for my defense? He could have been here today, but I can't contact him.
So I can't set a bond.
No, not bond. I'm saying, can I come back before you tomorrow with my attorney? Because I got one, but he just probably wasn't informed on this new charge.
Okay. All right. I want you to listen to what I'm saying. Okay. No matter what your lawyer says to me, I cannot set a bond for you because this has to go through a hearing. It may be in your best interest to tell your lawyer that bond was denied because of an allegation that you're on probation. As I've said in the other instances, lawyer may be able to talk to somebody and get you a bond later today, tomorrow, but that has to come through the DA's office. So isn't it better that your lawyer gets to working on getting you out rather than coming back here for me to tell him my hands are tied, I can't do anything?
Yes, I just let him work on it, I guess.
I mean, you want to come back tomorrow, I'll have them bring you back, but it's just going to be a big waste of everybody's time.
I mean, I understand what you're saying. I was just asking. He can talk to my defense and let him know that I wasn't even on probation. But I understand. I just let him wait.
Just tell him the bond was denied because the judge said that
I understand. He's already on it because I'm already dealing with some more probation stuff. I'm really supposed to be off probation. I ain't gonna talk about the case and all that, but he's
right.
Already. So.
Okay. Well, good luck to you, sir. All right, you're free to go back. Mr. Is it Souter?
Souter. Your Honor.
Okay. Okay, sir, you're charged with 1 count of public drunkenness. Bond is set by schedule at $1,000, which means it's automatically set. Do you believe you can post this bond?
No.
Your preliminary hearing date is going to be set for January 11th at 8:30 in the morning, courtroom 201. Do you want me to see if you qualify for the appointment of a lawyer?
Yeah.
All right, I'm going to find that you qualify. Sir, I'm going to appoint a lawyer to represent you. Do you have any questions of me?
No.
Okay, sir.
Court date
You said,
January.
did you say yes?
Say it again?
I said, do you have any questions of me?
Oh, yes, my court date January 11th.
Yes, sir, but this could happen faster than that. But that's the next date that I have set. Okay.
Alright.
This is a charge that, like I tell people, is not the crime of the century, and you should be able to work something out way before then. Okay.
Yeah.
All right. You're free to go back. Mr. Travis, sir, you're charged with 1 count of aggravated assault with a deadly weapon and 1 count of terroristic threats. Are you Mr. Travis?
Yes, sir, but what deadly weapon are you?
Okay. Let's see. These warrants were obtained on November 29th of this year.
I'll just speak before you say anything.
Yes, sir.
And so the allegations are that on this date, as it relates to the aggravated assault, that it says that you made an assault on the person of Rowena Kennedy.
I had ran into her car by accident, correct?
Mr. Travis, I'm gonna tell you one last time, allow the judge to finish.
I thought he
When he
did.
asks you to ask your question,
Okay.
that's the time you
Sorry
allow
about
to
this,
talk,
sir.
okay?
Yes, sir.
Thank you.
Sorry about that.
So, Mr. Travis, I'm gonna let you say whatever you want to say to me at the appropriate time. You asked about the aggravated assault charge, and I'm trying to explain it to
Yes,
you.
sorry about that, Judge.
No problem. The allegation is that you assaulted her with your vehicle when you hit her vehicle with your vehicle. That's the allegation. Okay. State has to prove these elements beyond a reasonable doubt. That's why we get you a lawyer if you want a lawyer, so you can start working on your defense.
Yes, sir.
So do you understand now the 2 charges?
Yes, sir.
There's an indication that you're on probation, so I can't
No,
set.
no, sir, I'm not on probation, sir. I was my probation had lifted up August this year.
Put your mask up.
I'm not on probation. I was
Okay.
on non-reporters, and for a year upon my releasing, I was on non-report. So that allegation right there is false. I'm off probation as of August of this year, or either August or September of this year.
Did you get the paperwork showing that your probation has been lifted?
No, sir. They only notified me and told me that I was in the August and September, where between August that my probation would be lifted because I was on non-reporters. And you probably could see that I was on non-reporters, and you probably also could see that that they gave me a year on that non-reporters for my releasing from Clay County Jail. So so I'm not on probation. So they just haven't probably taken out the system yet. That if you don't mind, is it any way that I can come back and see you tomorrow?
So, Mr. Travis, it's showing that you're on probation. Okay. Now,
Okay.
What I would encourage you to do you want me to appoint a lawyer to represent you?
Yes, sir. But I also want to be able to come back and see you tomorrow because them allegations right there of me being on probation is false, and y'all should be able to go back and verify that. Y'all should be able to verify it.
We can't.
If you don't mind me asking, Judge, how you can't do that if I was in the Clinton County system, and that's what they told me upon my releasing.
Okay. I'm telling you what I'm seeing. Okay. Now, it could be wrong. Okay. But if it's showing me that you're on probation and now you're here with new charges of aggravated assault with a deadly weapon and terrorist threats or acts, I cannot set bond.
Okay, can I, one more question?
Sure.
Is it in a way that, cause it say, I'm not supposed to be on probation. My probation supposed to have been lifted up August of this year, August of 2021 this year, which was done, which should have been in my report and it should be in the statements as well. Is it in a way that I could get somebody to go to that probation officer and notify them that they tell me that I'm still on probation for something that I'm not on probation?
So, Mr. Travis, I think there's like a disconnect somewhere where you understand you're charged with 2 serious felony offenses.
Yes, but I'm gonna beat them charges because I have proof. I'm gonna beat those charges, sir. I'm not worried about the charges though itself because one when I hit Marina Kennedy's vehicle.
Please, can I appoint a lawyer to represent you?
Yes, and please is it in a way that you could get that probation resolved?
I keep telling you no, but you keep asking me, is there a way for it to happen? That's why I appoint lawyers for you. Mr. Travis, let's try this out as just like a mental exercise.
What mental exercise?
I'm gonna tell you, try to stop getting arrested.
I am, okay, yes, sir.
That's
Yes, sir, but can I ask one more question?
Yes, sir.
The only reason that you wasn't able to set those a bond for me because it's on in the system that I'm still on probation, correct?
That's what I'm seeing. Based upon these charges and your criminal history, I may have denied bond anyway. So this is the thing, Mr. Travis, I don't want to sit here and have people sitting in jail. I have to be concerned about your rights and the public safety. And if you keep getting arrested and you keep.
I'm sorry, but I do have okay, they do have proof upon me, I guess the terrorist is threat or whatever.
Yep, they do.
Okay, but the allegation against the aggravated assault, when I have proof also about. Okay, go ahead, send me that, please. You don't mind? I'm done. Thank you.
Okay.
So you go assign me a point.
Yes, I did. I did.
And by any chance, would I still okay, but sir, I'm not on probation, but you go ahead. Can I go back and second my phone call, please?
Yes, sir.
All right, thank you.
You're welcome. Mr. Waters.
Good afternoon, Your Honor.
Good afternoon, Mr. Waters. Sir, you're charged with possession with intent to distribute marijuana, specifically bringing 3.28 pounds of marijuana through the airport. I'm going to set bond at $15,000. Do you believe you can post that bond?
I believe so, yes.
Do you plan on hiring your own lawyer?
I plan on hiring my own lawyer, but could you please appoint me a lawyer in the meantime? If that's possible.
You didn't fill out the form. Are you currently working?
Well, I'm not from Georgia. I am currently working. Yes, I do in-home care, but I'm not from Georgia, so I kind of didn't know how to fill out the paperwork properly.
Okay. How much do you earn per hour?
Per hour? Oh, maybe $13 or something.
Okay, I'm going to find that you qualify. I'm going to appoint a lawyer to represent you. You're going to have a preliminary hearing date set for January 10th at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out and you'll get a new court date in the mail. Do you have any other questions for me?
Oh, can you repeat my bill once for me again?
$15,000.
Thank you, sir.
Okay, you're free to go back. Mr. Wright,
Mr. Wright is in the, stay right now, stay right now. Mr. Wright is in a wheelchair, so I'm gonna turn around the camera, Your Honor.
Okay. Mr. Wright, sir, you're charged with 1 count of driving under the influence of alcohol to the extent that it made you a less safe driver. Bond's going to be set at $5,000 for that. And 1 count of following too closely in a vehicle, bond's going to be set at $500. So do you believe you can post this $5,500 bond?
No, sir.
Okay. Your preliminary hearing date is going to be set for January 11th at 8:30 in the morning, courtroom 201. That date will get waived upon your ability to bond out. Do you want me to see if you qualify for the appointment of a lawyer?
Yes.
I'm going to find that you qualify, Mr. Wright. I'm going to appoint a lawyer to represent you. Now, do you have any questions of me?
Yes, I was, seeking, I get a secret bond. I babysit my granddaughter and grandson during the daytime, and my daughter to go to work. We stay together, and I'm the only one keeping them, able to pay their bills, because I keep their kids, they don't have to send them to daycare or nothing like that. And, I didn't know I had, drinking alcohol.
Well, I'm sorry, I did say alcohol, but it says that you admitted to the police officer of consuming a dime bag of heroin before driving the vehicle. And I'm not going to ask you to confirm that, but that's the allegation that's in here. And they normally have body cams or dash cams. So if you said that, they have proof of that. So I'm not going to entertain your request. But I am appointing a lawyer to represent you. Okay, sir? All right, you're free to go back. I'm sorry, sir? Is he asking me to repeat the bond?
Yeah, his total bond, Your Honor, his total.
His total bond is $5,500.
All right.
All right, Mr. Willingham.
Yes, sir.
Oh, Jesus, 1240. Mr. Willingham, sir, you are in a little bit of a different boat than the others. All of the rights and privileges I explained in the beginning, they do apply to you. However, you're being held here on what's called a fugitive from justice warrant. And what that means is that there was information provided that, what is this, Cacassaw County Sheriff's Office in Louisiana, that they have a warrant for your arrest for 1 count of dangerous drugs, and they've indicated that they will extradite. Now, you have a right to challenge this process. If you believe that you're not Malik Willingham and you believe that you don't have a warrant for your arrest, you can say, I want to challenge this, and sometime within the next 90 days, there will be a hearing here in Clayton County to determine whether you are the person named in the warrant and whether the charges actually do exist. We don't have a trial in your case. We have no interest in your guilt or innocence. If after the end of that, between now and 90-day period, the judge determines that you are the person named in the warrant and these charges do exist, the judge will sign off on a governor's writ. And basically what happens after that is the state of Louisiana will have an initial period of 30 days to come and get you. If they don't come and get you within that 30-day period, they can request an additional 30 days for up to 60 days. If you know that you're the person named in the warrant and you believe that these charges may be valid, you may want to waive that process. And if you waive that process, everything moves a lot faster. But I can't promise you when this will happen. I encourage everyone who has fugitive from justice warrants to hire a lawyer in the place where the warrant is located, because I've seen jurisdictions where they say, well, hey, person has a warrant, we'll agree to a bond and we'll put this on a court date rather than flying out to Atlanta and going through that process. So have you had the opportunity to speak to anyone about this?
No, sir.
Do you have a lawyer representing you?
Not in Louisiana, sir.
Okay.
I do have a lawyer in Atlanta.
Okay. Has this made sense to you so far? Do you have any questions about anything that I've said?
My only question, so you said they have up to 30 days to come get me. If they don't come in 30 days, they can extend that 30 days even with an immediate extradition?
Yes, they can make a request to extend that 30-day period. It's not necessarily that it will happen.
Okay.
And the thing that I tell people also is that, let's say that they don't come and get you within the statutory period and the sheriff here releases you out of the front door. It doesn't make your charges go away. So you can bump into a law enforcement officer 5 minutes from getting released. They run your information and this process starts all over again. So it's always in your best interest to just attack it head on and deal with it.
Right. Okay. So as far as finding a lawyer in Louisiana, I would have to do that on my own. Like nobody can help me with that at all. Like I'm not from there at all, Florida.
I can't help you get a lawyer there. You would have to have family and friends assist you.
And then my last question would be, does it state like the address that they sent the court date to or anything like that? Cause I feel like it's paperwork, it's just paperwork. Because I moved from that place in July and I got into the trouble in January and the warrant was sent out November 10th. So I just feel like it's just, you know, in this situation with the address that I just never received the court date. I'm not running.
It doesn't show that on what I have, but that seems totally reasonable.
Sure. Okay. So in this case, I need to talk to a lawyer in Louisiana to see what's going on with that, correct?
Yes, because as I indicated, Clayton County has no interest in this whatsoever. If they receive a phone call or teletext or whatever from the sheriff's department, they're saying, hey, release him, you'll get released.
All right. Okay. I think that's it.
So do you want to have the hearing or you want to waive the hearing?
Waiving the hearing was the 30 days starting right now, right?
Yes, sir.
Yes. Yeah.
Okay, go ahead and sign the waivers and they'll send it over to me and I'll sign it and it'll go back with the paperwork today. And then things will get, they'll get moving.
Okay, so the waiver, so this is me saying that I believe, so this is me saying that it's my
That
name.
you're waiving that hearing to determine whether you are the person named in the warrant and whether the charges exist. It's not a guilty plea. It's not an acknowledgement of guilt or anything like that.
Right, and then they have 30 days and we can extend that 30 days, correct?
Yes, and the people in the fugitive squad may know kind of what's happening with your case because they're the ones that communicate with the other jurisdictions, and so they may know if there's already a plan in place to come get you.
Mm-hmm. Okay.
All right.
All right,
Okay,
thanks.
sir, you are free to go back.
All right. Okay, Your Honor, you sign it.
Okay.
That would conclude our calendar for today, Judge.
Thank you. We made it through.
We did.
Have a good day.